To those members of the public who might not know much about these interims, you know, we don't actually pass legislation during interims. We simply study topics once a month or almost once a month for several days. So what we're doing today is having a presentation, and today we're going to have Jim Rubenstein from the Department of Corrections, who's going to give us an update on the Justice Reinvestment Act. So I'm sure it will be very interesting. Jim?
Good morning, and thank you, Mr. Chair. I'm Jim Rubenstein, Commissioner, Division of Corrections, and thank you for the opportunity to hopefully give you a brief overview of how Justice Reinvestment, Senate Bill 371, is moving forward here in West Virginia. Have a short PowerPoint presentation, and I believe everybody has this presentation in front of them. The first slide that we wanted to show was actually the decrease in the Division of Corrections in the population of those offenders sentenced to the Division of Corrections in fiscal year 2014. And as you can see, there was a decrease of 3.5%, and the number of Division of Corrections inmates held in the regional jails decreased by 48%. Now the number of inmates held in our facilities increased a little bit over 10%, and that was due to a number of upgrades at some of our facilities of increasing beds. And then also, if you recall, the industrial home for youth at Salem was transitioned from juveniles to an adult facility, and I know that there will be a tour of Salem tomorrow for the Regional Jail and Correctional Facility Oversight Committee, and I'm sure anybody else interested. And we have 380 adult male inmates housed at Salem. One thing I would like to point out is that from the Justice Reinvestment and from the Council of State Governments when they were in, and many of you might recall the early projections that actually upon the passage of Senate Bill 371, there was going to be an increase in the prison population over a 4 or 5 year period of time before there was actually any type of leveling and even to see a decrease. So we were pleasantly surprised right off the bat to see the population see a decrease, and then actually at one point in time, and this was really right during the session when 371 was passed, we had at one point in time there were over 1,700 inmates who had been sentenced to the Division of Corrections that were being held in one of the 10 regional jails, and that has been down now into the mid 800 to the high 800 number on a fairly consistent basis. Some of the primary factors contributed to the reduction. Policy changes by the Parole Board have led to more releases from Division of Corrections custody, increased use of graduated sanctions for parolees in lieu of revocation, and we were actually seeing a slower annual increase in the number of commitments from circuit courts, and we feel that those that Senate Bill 371 also gave the courts and probation a greater use of graduated sanctions on the front end. So we think a combination of some of these factors has led to the reduction that we're currently seeing. The next graph just shows from 2000 through 2013, and it you can see that in 2007 there was 3,449 commitments. 2,871 releases. So during the period of time when the prison population was really growing, you can see just by simple math that the commitments were far exceeding the releases from custody. In 2013, you can see that actually there were more releases than commitments. And I know in some of the committees there's been a lot of talk and discussion concerning from the parole grant rate and from further considerations. But the bottom line is that you can see that the further considerations decrease dramatically, and an inmate can have a further consideration because they don't have an approved home plan, they've not completed certain parts of programming or treatment that is necessary. But Senate Bill 371 and then strengthening the community corrections programs really put some teeth into it, where the parole board can grant parole, and a condition of parole would be to complete a program in a community-based day report center instead of remaining in one of our correctional facilities. So again, as long as we can see the increase of releases compared to commitments, we're going to be in pretty good shape. And hopefully, as we'll show here during the presentation, is that really not all of the aspects of Senate Bill 371 have been implemented across the board yet either. And then, you know, to make sure that we're adequately doing this, there is a data tracking and analysis, and we share that with the council, state government. We review it internally, and not only within the Division of Corrections, but within all the affected agencies. And it's also shared with the Justice Reinvestment Working Group. I know out of the Division of Corrections, every Monday morning, Brad Douglas, our Director of Research, has a committee of our folks that has a telephone conference with the council, state government, as well as others, to just, you know, make sure that we're all on the same page and that the right hand knows what the left is doing. And if there are any questions or concerns or any type of issues, having these weekly meetings has allowed us to sort of nip things rather quickly instead of letting anything fester, and it's been most helpful. Some of the major justice reinvestment initiatives, one of them was the inmate psychological evaluation process. 371 requires a two-tier evaluation, which is a quicker appraisal followed by a full evaluation if needed. A lot of the further considerations, or a fair number I should say, by the parole board when somebody was appearing in front of them, was for the need for an updated psychological. What we were doing before 371 was every offender that was sentenced to the Division of Corrections at intake was given a full-blown psychological at a, you know, certainly a higher cost. But when council state government came in and when they were looking at this, they were seeing that actually 70 to 80% of our inmates did not have serious psychological issues, which would have the need for a full-blown psychological. So we're now doing an appraisal of everybody, which gives us a good indication. And then if an individual needs a full psychological, that is taken care of, and certainly that's an extreme cost-saving measure for the division. And by implementing this process, again, it does allow us to prepare inmates through processing and to prepare them to see the parole board in quicker fashion. And we're also working to be able to handle those Division of Corrections inmates who are still housed in one of the 10 regional jails, so that we can get them up to speed as quick as possible and we'll talk about some other things as far as programming a little bit further into the presentation. The mandatory supervision phase of 371 requires inmates who discharge their sentence and committed their crime after July 1st, 2013 to spend 1 year on mandatory supervision if convicted of a violent offense, and that is spelled out within Senate Bill 371. And then up to 180 days on mandatory supervision if convicted of a nonviolent offense, but then this has to be ordered by the court. This was something early on that we were looking at this being mandatory as well, but upon passage it wasn't. I can tell you that we've seen, I believe, one judge who has actually utilized this 180 days, so where somebody would have 6 months supervision on a nonviolent offense, but again, that has to be ordered by the judge. Those on the violent offense, the adjustments occur, and I believe that the first inmate who will fall under that category for the violent offense won't be till early next year that they will go out on the 1 year supervision. And then, as you can see, that we have 22 inmates who will spend time on the mandatory supervision if they discharge their sentences without being paroled. And again, the earliest will be 2015. The Division of Corrections, with Senate Bill 371 and House Bill 457, or is it 455? 457, required that the Division of Corrections offer programming to those inmates sentenced to us housed in one of the regional jail authorities, in one of the regional jails. And we've started offering cognitive behavioral programming, which is thinking for a change, and we'll be implementing substance abuse and other classes in the near future. House Bill 457 allowed us to hire 10 more correctional counselor twos. Those folks are actually housed at one of our correctional facilities, but then they're able to go into one of the regional jails to teach classes. And the classes that will be offered to those offenders in the regional jail are the exact same classes that are offered in one of our correctional facilities. So when they appear in front of the parole board, it's rather seamless as far as from the programming aspect. And then, you know, this is just baby steps to get things up and running, and certainly the thought would be the opportunity to offer more classes later on. But again, there is from the physical structure of the regional jails, there are limitations as far as space and schedules, and plus the county jail inmates that they serve as well. But we're thinking that, you know, with some of the programs that we're offering, we'll be able to reach out to them as well because of some of their needs, and at least provide something to those individuals who are in one of the jails. Senate Bill 371 encourages to create a committee to investigate and make recommendations to more effectively share these issues between agencies, and the committee has been formed. It's chaired by Senator Laird. We participate in that, and there has been 2 meetings so far. And again, this, and I'm sorry, Loida, what is WVSC, the sharing committee? And it's folks from a number of different agencies and entities, as well as the public, to hopefully understand the issues and the release of offenders back into society. Community supervision quality standards. Senate Bill 371 calls on the Governor's Committee on Crime, Delinquency, and Corrections, Community Corrections Subcommittee to create quality assurance standards for probation, parole, and community corrections. That committee has created a working group, and again, we're participating in that. And really one of the things I really liked about 371 is that the community corrections programs, although good programs, were really scattered across the board, across the state. And 371 really puts some teeth of what these programs should look like, what they should offer, what it should be a blend of, and we'll see the benefits from that as well. That's a work in progress, but it is in the works as well. Parole assessment and eligibility, although not specifically required by Senate Bill 371, the Council of State Governments has attained the services of Catherine McVeigh, and she's a nationally recognized consultant in the topics of parole board operations and parole supervision. She's a pleasure to work with. She has a vast amount of experience. She previously was chairwoman of the Pennsylvania Parole Board, has been a consultant across the United States. She's been working with the Parole Board, the Division of Corrections, and others, and she has made some wonderful strides with the division and the Parole Board. And actually, the Parole Board will implement an assessment instrument, a validated assessment instrument that's been used in other states to assist in their decision-making process, and they'll start utilizing that instrument in October of this year. Two of the key positions out of Senate Bill 371 within the Division of Corrections created a full-time transitional housing and employment coordinator. And then we're also working on a program within the Division of Corrections where we can grant small short-term reentry loans to parolees. And I realize at times by saying that it generates some criticism, but if you look at those two positions, a lot of times reentry of an offender, the two most critical areas are to find adequate housing and to find employment. So by being able to have these two positions, and they work right under our Director of Parole Services. So what we see then with the short-term loans is that there's just a lot of times that an offender needs a little bit of money to get appropriate boots, coveralls, to be able to start a job and doesn't have it, to be able to get into an apartment. And again, it's a loan program. Our general counsel is working on this to make sure the legalities of everything. It's been used in other states, and instead of holding somebody in a $25,000 a year prison bed for $200 or $300 to get them re-entered and working under parole supervision, we feel that we'll see many benefits from that as well. We had both of these positions filled, and sadly the housing person that we had fell seriously ill and had to resign rather abruptly, and we're getting ready to interview to hire that position again. But we've also appointed a small working group to tackle again the issues on the reentry loans. And as I mentioned, there are some administrative hurdles, but we're working on those and feel that we'll overcome whatever and be able to move forward on that. The graduated sanctions for parole, Senate Bill 371 includes provisions that, and certainly, you know, there are just, when somebody's out on parole, there are certain instances of what somebody can do where it's a no-brainer as far as they need to be taken off the street, they need to be in jail, and they need to have their parole revoked and to go back to prison. But that's not always the case, and the statistics from the Council of State Government indicated that a high number that were being returned for technical violations, and many of you have heard me talk about where the high number, not only in society and in West Virginia, but certainly within our corrections environment, of those individuals who have drug and alcohol addictions. And so when they're out on parole supervision, sadly, some of them still drink and some of them still use. They're not committing a crime, although we know that led to their criminal history. The graduated sanctions allows us via 60 and 120-day jail incarcerations prior to revoking parole to try to work with them, get their heads straight, and get them back out under parole supervision without going through the process of revoking parole. And so we've started that. We're working with Catherine McVeigh and the Parole Board, so that we've got that comprehensive continuum of sanctions across the parole services within the Division of Corrections and the Parole Board. And we feel that this is really a good thing, and it's worked very well in other states. And it allows us to work with individuals to try to, get them and get their head straight, literally, where they can remain out on parole supervision and reenter society, because many of them have wonderful skills. They've got good employment. They've got an addiction, which many of us are very familiar with. There's also part of 371, which allows graduated sanctions for probation, home confinement, and drug courts. So this allows the court and probation to use these graduated sanctions on the front end as well, short of incarceration within the Division of Corrections. The Senate bill requires that these stays, the graduated sanction stays, are paid for by the Division of Corrections, based on the philosophy that keeping them out at this cost with the potential to not be incarcerated within a corrections facility at the $25,000, $26,000 a year is still a cost-saving measure, and the courts are utilizing this approach as well. And you can see that the Division of Corrections and the Regional Jail Authority have implemented financial procedures where we can process, audit, and pay the bills. And then from the study group that Senator Laird is chairing, we continue to talk about this topic, and we're encouraging the adoption of a standardized court order for these types of incarcerations. Accelerated parole. This was created before Senate Bill 371. Been a very frustrating, slow-moving animal, to say the least, but one, as commissioner, that I felt was salvageable and something that we should stick with. And the Council of State Governments has made some recommendations, some policy revisions to us and the Parole Board, and so we're working together on the accelerated parole to hopefully see some of the benefits of that certainly are out there. Just we've got to get on the same page and be in agreement on this plan, but we're working towards that, and we're working very closely together to achieve that. There's a master agreement with the Division of Justice and Community Services for Community Corrections Program reimbursements, this would be where those programs where we would have individuals who would go into, as I was mentioning earlier, it could be part of parole sanction, program completion, treatment, attending AA meetings, NA meetings, things of that nature. That could be through community corrections, and that where there could be a billing to the DOC for services provided to parolees. And we've had some preliminary discussions, and we'll be developing a draft agreement for review in the near future. West Virginia applied for and received a grant of $550,000 from the Bureau of Justice Assistance to pay for some of the Justice Reinvestment implementation related tasks. And so that funding has been approved for a number of staff trainings on evidence-based practices, substance abuse programming, program evaluation techniques, and cognitive behavior programs, and also for consulting fees, enhancement to computer systems, and actually to have hire a person to coordinate and oversee all of these efforts. And one of the things that we're excited about and that receiving training in is, you know, we want to make sure, again, to be a good steward of the taxpayers' money, that the programs that are being offered are effective. And so to make sure that that we use these evidence-based practices within all of these programs, and that we're receiving the outcomes that we would hope for, then it would be money well spent. If we see otherwise, then we would need to look at other different type programs, because we don't want, just for the sake of we've always done it that way or offered this program, to keep doing that if it's not being effective and getting the results that we feel that it should. So that is a very quick overview of 371. Before answering any questions, though, I would like to thank the legislature for your passage of 371 and for House Bill 457. And hopefully from this presentation you can see by passage of that bill that we are seeing some positive results much earlier than we anticipated. But again, I thank you for the opportunity to present this morning, and I'll be more than happy to try to answer any questions that you might have.
Mr. Rubenstein, with respect to the psychological evaluation, do those evaluations also include the genesis of any problems that are identified? And if so, what are we doing with that data?
Delegate Ireland, the initial assessment would advise the psychologist whether there were any serious issues or concerns that would then require the full-blown psychological assessment, at which time some of those needs, conditions, etc., would be become better known. And then and this is done at intake, so anybody that comes into the Division of Corrections, they first go through an intake procedure where we look at not only doing the psychological assessment and possibly the full-blown psychological, but we look at their current crime, their criminal history, a lot of different factors, the length of their sentence, whether they've been incarcerated with us before, and actually at intake they're given a classification. Ours is a 1 to 5. 1 is minimum security and 5 is maximum security, with 2, 3, 4 in between, so that we can place them at the proper correctional facility. And also that we can get them involved in whatever educational, vocational programming, and then from psychological or treatment issues that are identified, that we can provide, the appropriate service as well. So those would be identified, and then we would, place them where as needed to receive those type services.
But what I understand you to say, though, is that you evaluate them and they're at a given point psychologically, and then they're treated accordingly.
Yes.
So my question is, how do they get to that point psychologically? And was it an issue of hereditary, or was it an issue of abuse when they were a child, or what caused them to be at whatever level they are? That's a problem for them. And if we identify that, then what are we doing with that data in order to keep folks out of that position to start with?
And not being a psychologist or psychiatrist, I'll give my best stab at this, but everybody is given the original assessment. And going back to the Council of State Governments, what they saw was that a high percentage of those individuals sentenced to the Division of Corrections really don't have severe psychological problems or issues. And their point was, we were paying for a full-blown psychological for individuals who really didn't need a full-blown psychological. So the assessment, what it's really been showing us is what Council of State Governments indicated, is that a lot of the individuals, although with criminal history, substance abuse issues and things of that nature, don't have real severe psychological problems. If the initial assessment, though, indicates they're given the full-blown psychological, we have a locked mental health unit at Mount Olive Correctional Complex for those severe cases of individuals with mental disorders, mental disabilities that need to be confined on that unit to receive the appropriate treatment, and because some of them would be a danger to others. But it's a small percentage, and then we're looking at, though, from the whole intake process with family history, education, any types of abuse, sexual abuse or whatever, to try to put that snapshot together of treatment for a successful reentry, because there's just, what we see sadly is just a lot of cycles over the years within families of this type of abuse, and where, some just see it as normal. And so we're going to work diligently while they're incarcerated with us to try to break that cycle. Thank you. Thank you very much.
Chair determines that there is a quorum present. You have before you the minutes from the June 17th and June 18th meeting. Are there any amendments or corrections to be made? If not, Chairman Palumbo moves the adoption of those minutes. All those in favor say aye. Aye. Those opposed, the ayes appear to have it. The ayes do have it. I declare the minutes adopted. Is there other business to come before the committee? If not, Chairman Palumbo moves we adjourn. All those in favor say aye.